Can somebody, guys? Good morning. Good morning. Welcome to the Constitutional Court of South Africa. My name is Nathi Mncube. I just want to make some few announcements. We will be starting shortly. As usual, we would request that you switch off your phones or you put them on silent. If you need to find bathrooms, they will be on your way out on your right-hand side. Another announcement is that when the judiciary procession comes in, we request that you stand for them and you do the same as they leave at the end of the program. There will be the annual reports as you leave outside, so you can take a copy, and also the speech of the Chief Justice. We thank you for coming, and we'll be starting very shortly. Thank you. May I ask that we stand for the judiciary procession, please?
Chief Justice of the Republic of South Africa, members of the Judiciary, President of the Supreme Court of Appeal, Justice Maya, Justices of the Constitutional Court, Honorable Mr. Lechisa Zenoli, Deputy Speaker of the National Assembly, Honorable Ms. Sylvia Lucas, Deputy Chairperson of the National Council of Provinces, Honorable Ms. Patricia de Lille, Minister of Public Works and Infrastructure, Honorable Mr. John Jeffrey, Deputy Minister of Justice and Constitutional Development, Honorable Mr. Bulelani Magwanishe, Chairperson of the Portfolio Committee on Justice and Correctional Services, and other honorable members of that portfolio committee, justices of the Supreme Court of Appeal, judges president, deputy judges president, and judges, regional court presidents, chief magistrates, and senior magistrates, and all other members of the judiciary present, the personal guests of the Chief Justice, members of the Judicial Service Commission, members of the Council of the South African Judicial Education Institute, members of the Legal Fraternity, Ms. Meme Sejosengwe, the Secretary General of the Office of the Chief Justice, and all OCJ officials in attendance, and those following these proceedings on live streaming all over the country, heads of government departments and officials in attendance today, members of the Audit and Risk Committee of the OCJ, members of the National Efficiency Enhancement Committee, and officials of these stakeholder departments and state institutions, representatives of state institutions, fellow South Africans, members of the media, ladies and gentlemen, I greet you this morning. I take this opportunity to welcome all of you to this very important occasion in our country, the second of its kind after the one that took place on the 23rd of November last year. I welcome all of you and want to thank you for having taken time to be with us today and to share this important occasion with us. We are going to immediately start with our program, and I'm going to invite Judge President Liu, who is Chairperson of the Judicial Accountability Committee, to come forward to outline the purpose of the Judiciary Day that we have today. Justice Liu.
Honorable Chief Justice Mogoeng, the Chief Justice of the Republic of South Africa, and Mrs. Mogoeng, Honorable Reizondo, Deputy Chief Justice of the Republic of South Africa. President Mandisa Maya, the President of the Supreme Court of Appeal. Justices of the Constitutional Court. Justices of the Supreme Court of Appeal. Judge President, Deputy Judges Presidents, and the judges. Regional Court Presidents, Chief Magistrates, and Senior Magistrates. Excuse me, and all other members of the judiciary here present. Honorable Patricia de Lille, MP, Minister of Public Works and Infrastructure. Honorable John Jeffrey, MP, Deputy Minister of Justice and Constitutional Development. Honorable Lichisa Tsinoli, MP, Deputy Speaker of the National Assembly. Honorable Sylvia Lucas, MP, Deputy Chairperson of the National Council of Provinces. Honorable Bulelani Makhwanishe, MP, Chairperson of the Portfolio Committee on Justice and Correctional Services, and honorable members of the Portfolio Committee, honored guests, ladies and gentlemen. Section 165 of the Constitution provides that the judicial authority of the Republic is vested in the courts, that the courts are independent and subject only to the Constitution and the law, which they must only apply impartially and without fear, favor, and prejudice. This applies to all judicial officers, that is, judges and magistrates, as well as presiding officers in other courts established or recognized in terms of an Act of Parliament, including any court of a status similar to either the High Courts or the Magistrates' Courts. The independence of the judiciary is protected by Section 165(3) of the Constitution, which provides that no person or organ of state may interfere with the functioning of the courts. In actual fact, Section 165(4) behoves organs of state through legislative and other measures to assist and protect the courts to ensure the independence, impartiality, dignity, accessibility, and effectiveness of the courts. I reiterate what I said last year during this occasion, that throughout the world, the judiciary remains accountable to the people for the power and authority bestowed upon it. In many African and other democracies, the judiciary has led this process. It developed a strategic plan for implementation of its vision, set targets for measuring its performance, and developed ways to report on its work to the public itself. This plan was hashed at a judicial retreat held on the 3rd to the 5th of August 2012, which was led by the Chief Justice Mogoeng together with the heads of courts of the South African Superior Courts and senior judges. The main purpose of the retreat was to put our heads together and reflect on the state of affairs in our courts. That is, whether we as the judiciary and other stakeholders effectively administer justice to the majority of our people who appear in our courts. The leadership of the judiciary, after intensive deliberations, came up with a plan of action aimed at improving the overall performance and functioning of our courts. The Chief Justice Mogoeng emphasized the need for change in the manner in which the judiciary, and I add, those who are charged with the responsibility to administer justice, approach their task of delivering their mandate vested in them by the Constitution. Section 165(6), which was added by Section 1 of the Constitution's 17th Amendment Act of 2012, provides that the Chief Justice is the head of the judiciary and exercises responsibility over the establishment and monitoring of norms and standards for the exercise of judicial functions of all courts. I emphasize all courts as defined in Section 166 of the Constitution. This provision was reinforced in Section 8 of the Superior Courts Act number 10 of 2013, which act came into effect on the 12th of August 2013. Consequently, on the 26th of February 2014, the Chief Justice Mogoeng signed and published norms and standards for the performance of judicial functions. These norms and standards provide, amongst others, that judicial officers should expeditiously finalize cases, both civil and criminal matters. Judicial officers, when they are appointed, they take an oath or solemnly affirm that they will be faithful to the Republic of South Africa, that they will protect the Constitution and are subject to the Constitution and the law. We account through our court judgments where we give reasons for whatever decision we reach. This, however, does not mean we should not account for the performance in our courts. The Judicial Accountability Committee is a subcommittee of the heads of courts and was established by the heads of court to address the following issues. Amongst others, what should judges do to improve court performance? What is the most effective way of gathering statistics? How should the judiciary communicate effectively its work to the public in relation to progress made, the challenges, and the required resources? And how best the judiciary can ensure that it reviews its targets on an ongoing basis. The Judiciary Annual Report reflects indicators which were drafted by the judges at a workshop. This is work in progress, as this is only the second year in the history of the judiciary that court performance is accounted for in this way. The judiciary is in the process of developing a strategic plan for the period 2020 to 2025, and the strategic plan will also include performance information for the Magistrates' Court. Although the South African Judiciary has certainly taken a step in the right direction, it has a long way to go. As the process of monitoring and reporting on judicial performance matures, the indicators and information reported on will become more significant and paint a clearer picture of the true performances of the South African courts. In the process of maturing with regard to reporting, inputs and comments from the public are always welcome. The information in this report has been internally audited for the first time, and this is an important step in refining the process and ensuring the veracity of the information presented. The 2018-2019 annual report also contains descriptions and explanations for the indicators. This will be of assistance when assessing the performance information. Ladies and gentlemen, with this overview, may you please welcome and I invite the Chief Justice Mogoeng to present his keynote address. I thank you all.
Thank you very much, Judge President Liu, for outlining so clearly the purpose of the Judiciary Day, the purpose of today's function. Thank you very much. At this stage, I would like to announce that we are going to have the Chief Justice of the Republic who will come to deliver the keynote address effectively, us accounting, and of course there is documentation which has got all the details, but he will give the keynote address, the Chief Justice of the Republic of South Africa.
the Deputy Chief Justice of the Republic, Ray Zondo, President of the Supreme Court of Appeal and of the South African Chapter of the International Women Judges Association, Justice Mandi Samaya, Justices of the Constitutional Court, the Honorable Deputy Speaker of the National Assembly, Honorable Lechisa Tsenuri, the Honorable Deputy Chairperson of the National Council of Provinces, Honorable Sylvia Lucas, the Honorable Minister of Public Works and Infrastructure, Honorable Patricia de Lille, the Honorable Deputy Minister of Justice and Constitutional Development, Honorable John Jeffrey, the Honorable Chairperson of the Portfolio Committee on Justice and Correctional Services, Honorable Magwanishe, Honorable members of that crucial committee present, Justices of the Supreme Court of Appeal, Judges Presidents, Deputy Judges Presidents, and Judges, Regional Court Presidents, Chief Magistrates and Senior Magistrates, other judicial colleagues present, Advocate Mpaga SC on behalf of the General Counsel of Bar Council, Advocate Shamila Batoi, the head of the prosecuting authority of our country, my spiritual parents, led by Pastor Ibitayo and Pastor Mrs. Ibitayo, members of the Judicial Service Commission, members of the Council of the South African Judicial Education Institute, colleagues in the legal fraternity, the Secretary General of the Office of the Chief Justice, Ms. Mmesi Josengwe, the Director General of the Department of Justice and Constitutional Development, Mr. Madonsela, other Directors Generals that I may not have seen, members of the Audit and Risk Committee of the Office of the Chief Justice, colleagues in the National Efficiency Enhancement Committee, representatives of other state institutions, members of the media, fellow South Africans, I greet you this morning. We cherish and treasure the privilege bestowed upon us to be bearers of the constitutional mandate, to be final arbiters in all legal disputes in this country. And we appreciate deeply the opportunity to present a somewhat brief report on essentially where we come from, where we are, where we need to be, and how. I think it is necessary to give some background to our approach to our accounting responsibilities because there's been a bit of misunderstanding. It wasn't a thumb suck. We reflected on how other jurisdictions go about accounting for the execution of their constitutional mandates. And some of the countries we look to are Singapore and Malaysia, but we paid particular attention to how the United States of America, the United Kingdom, Ireland, Kenya, and Uganda does it, because there are a lot of similarities in relation to their particular mandate and ours and how they are expected to execute it. So we decided to pay particular attention on ensuring that, unlike before, there is a somewhat well-coordinated structure in place. Because in the past, you would have a Chief Justice there and judges presidents going about their business, only responding to an invitation by the Chief Justice to have a meeting together to chart the way forward to the judiciary as a matter of courtesy. There was nothing either in the Constitution or in any law that imposed a semblance of an obligation on them. to respond positively to a call to come together and deal with issues that required attention from the judiciary. So it is this and other major issues that we need to focus on. We didn't have any judicial case management to write home about. We didn't have norms and standards to write home about. We didn't have any well-organized machinery at a national, provincial, regional, and district level that brings together all the critical role players in the justice system together. We didn't have any form of mediation. We didn't have much of what is required for the court system to function as efficiently as the people of South Africa expect of it to. So I know that some are concerned about the finer details. Instead of saying, at long last, here is a vehicle, it has wheels and a steering wheel, and there is a clear direction in relation to where it is going and how it hopes to get there. People are worried more about, what about the condition of the seat? What about the dashboard? When are you going to fix the cracks on the dashboard? We're very much alive because we operate in this space. So what is it that cries out for fundamental change? And we will get to the nitty-gritties that people seem to be concerned about in due course. Some of our people are saying, your audit reports do not tell us when did each court receive which case, when did that case get enrolled, and how long did it take you to move from enrollment to the end? We very deliberately decided to focus only on the commencement of the trial or the hearing all the way through to reserving or delivering judgment, and if a judgment is reserved, how long then does it or did it take those that delayed to move from the reserved judgment up to finality? And you may ask, but it's important for the purpose of measuring performance to know when the case got into the court system and how long it moved from there to the enrollment. It is true. But the priority is to focus on matters that fall squarely on the shoulders of judicial officers. In other words, matters that judges have the unmistakable or the unquestionable sole responsibility to determine the pace at which they are going to move. But after enrollment, you still have judicial officers and all sorts of other people, including witnesses and the police in case of criminal cases to contend with. So you are not in a position to really blame the judicial officers for not having done as well as they are expected to in relation to that period or that stage, because there are many other players involved. That is why we have established the National Efficiency Enhancement Committee and the Provincial Efficiency Enhancement Committee. That brings us together as key role players in the broader justice system. Deal with issues that cause delay that are not exclusively under the control of the judiciary. So for the past 8 years or so, we've been very deliberate and intentional in ensuring that whatever is necessary to answer the cry of the South African public about the delays in the system is done. The groundwork, the fundamentals that are necessary to move us to that point are in place to help us move with deliberate speed. We could have included, for instance, the number of postponements for each and every case. It's not feasible. It's not only a very laborious exercise, it's also very costly. Too costly for the limited resources at our command, particularly because we truly are thinly staffed administratively. So what we have decided to do as one of the major issues or developments to be factored in the way we do things is to modernize courts. And that, of course, depends on funding. I may have mentioned it to some that I was approached by somebody to offer in 600 million rand so that we can modernize. But I know that person, I know that institution, I rejected it with the necessary contempt, because that's how capture happens. We don't want to be funded in the middle of the night, however people may posture as benevolent givers of assistance. So we need, and we have done a lot of work to develop a court automatization system based on what we have seen in the US, in China, and other jurisdictions. Funding has been the major frustration. But Judge President Mlambo and other colleagues in our Modernization Committee would tell you, good progress has been made. Case lines, a system now that deals with case lines is in place. A pilot project is underway in the Gauteng courts under the supervision of Judge President Mlambo. So we tend to be compared to jurisdictions that have been well organized for well over 100 years, and I think unfairly so, and selectively as well, because we say without any fear of contradiction that if you compare us with even some of these jurisdictions, in all respect, in our 25 years of existence, many of them still have a bit to learn from us. We say it with all sense of humility. Broadly speaking, in relation to the focus on matters that are of great significance, we've made a lot of progress in the limited period that we have had to bring about change. Now, I think we indicated in the past what the court modernization program is going to entail. It's in the report. It's all about e-filing. It's all about capturing that data that our people need for the purpose of judging our performance. We're very much alive to that. We want to develop a system that will enable us, through our smartphones and iPads, wheresoever we may be, to be able to tell what is happening in any court, anywhere in the country, and to tell immediately whether there has been a postponement and what the reason for the postponement is, so that when intervention is speedily required, we may do so. So we are building systems with norms and standards in place, judicial case management and court annex mediation embraced, and automatization being at an admirable stage under the circumstances. We are satisfied that a lot of good fruit is indeed being yielded by our efforts. Ask any practicing lawyers whether in our higher courts where these innovative measures have been introduced, performance is reducing or declining. I believe that they will tell you that there has been a lot of progress, because they used to wait much longer to get a date, even for years, to get a date for the hearing. Because of the systems that we have introduced, it's no longer so. The judiciary is in the process of developing a strategic plan for the years to come, as the Judge President has indicated. And the 2018-2019 Annual Report contains descriptions and explanations for the indicators to assist those assessing the performance information. I must just say, because it has been raised, we can't use the appeals to measure the performance of judges. I say it because people say, to get a good sense of whether judges are doing well, and magistrates, you've got to track how many of his or her judgments have been appealed against. I don't think it helps. People appeal either because they have resources or they don't, and others appeal because they are justifiably or unjustifiably led to believe that they have a strong case. You also cannot use as a yardstick for performance whether the appeal was successful or unsuccessful. we as the Constitutional Court on a regular basis set aside judgments of the second highest court in the land, the Supreme Court of Appeal. Not because there is anything wrong about the quality of the judgments that our colleagues have delivered, and the same applies to all other courts. Most of the time, it is a difference of understanding of the issues of importance to us in relation to the quality of judgments or performance, is whether or not there is a sound appreciation of the legal principles and whether the approach is that can be expected of a competent judicial officer. But to say whether an appeal goes this way or that way would be highly misleading. After all, even the judges of the Constitutional Court can have at times, I think there's a record of about 5 judgments. Who is competent, who is incompetent then among us? So the appeals, or the noting of the appeals and their outcomes, would be a less than satisfactory yardstick for judging the performance of the judiciary. My sister, Advocate Batoya, and your colleagues, I hope you won't see this as an attack, because it is not. But there is a problem that needs to be corrected happily. The chair and members of the portfolio committee are here, the public is here. And it relates to how the National Prosecuting Authority assesses its performance. I think it is wrong to use the conviction rate as the test for determining whether the prosecuting authority lives up to the expectations that flow from its constitutional mandate or not. Prosecutors don't convict anybody. How then do you credit them or disadvantage them because there have not been convictions? How do you hold them responsible for what magistrates and judges do? You will never be able to tell whether prosecutors do what they are expected to do for as long as you use how many convictions are there, how many acquittals are there as a yardstick for determining whether they are doing what is required of them. The responsibility of the prosecutors is no different from the responsibility of members of the bar or of the attorney's profession. Theirs is to present their cases to the best of their ability and leave the rest to the judicial officers to do what needs to be done. So another yardstick must be determined. Otherwise, even in circumstances where, as they know, they are under a legal obligation to make available information that could lead to the legitimate acquittal of an accused person, because of this pressure, they will have to insist on conviction, even if it is not in the interest of justice to do so. This thing must be revisited, it must be done correctly, and it doesn't matter what other nations are doing about it. It's a logical thing, and we've got to confront it, interrogate it, and say why we believe it's a reliable yardstick for determining the performance of the prosecuting authority. I summarize court performance as follows. During the period under review, the superior courts managed to perform at 70%. The following targets were not met. A percentage of constitutional court cases finalized, 76% against our target of 80%. Percentage of competition appeal court cases finalized, 57% against the target of 90%. And a number of criminal cases on high court roll for more than 12 months is significant for understandable reasons. The challenges experienced by the judiciary in this regard have been exacerbated by the ever-increasing workload on these courts, notwithstanding the fact that the judicial capacity has never been increased. The 17th Constitution Amendment Act has really disadvantaged the Constitutional Court and undermined its capacity to deliver as expected. And here is the reason. We have no possibility, unlike some other comparable courts, and even unlike the Supreme Court of Appeal, of sitting in panels. It's either all 11 of us must sit or 8. And even then, every judgment that is written, every application that is processed, each and every one of us must bring his or her mind to bear on it. It takes too long, embarrassingly long, particularly in relation to complex matters and matters that are just too involved. So much so that some of us have been wondering whether the time has perhaps not come to increase the number of judges of the Constitutional Court. Some people say, no, it will never be the same. It will lose something. Or to merge the Constitutional Court with the Supreme Court of Appeal. After all, the judges of these two courts earn the same salary. Whatever the case may be, it looks like something radical or fundamental needs to be done to inject functionality and more efficiency in the operations of the Constitutional Court. What I have discovered with my colleagues in Germany is that they draw judges from the likes of the Supreme Court of Appeal, the High Court, and senior officials from the National Prosecuting Authority to process matters for them and even be deeply involved in the crafting of judgments and orders. What happens here is that we have the benefit of clerks, most of whom come straight from the university with very limited, if any, practical experience to be of assistance where it matters the most. They are doing a good job, but not up to the level where assistance is critically required, and that is in relation to the judgments. The Supreme Court of Appeal, I alluded to it, it has done, I think, better than any other court, considering the workload. And it is the possibility to have panels in place for the determination of the issues that I believe has greatly enhanced the possibility of finalizing cases speedily. Our high courts have really done well under extremely challenging circumstances. The statistics are there. I mean, they had a total of 145,127 civil cases and finalized 114,650 and 13,140 criminal cases and finalized 10,666. So I think there's good progress. We must just focus on what else is required of this court to be able to do much better than it has. The specialist courts have also done well. I mean, the Labor Appeal Court, for instance, had 5,915 cases. The Labor Court and the Labor Appeal Court, and they've been able to finalize 3,756 cases, and more judicial capacity is, of course, required there. The Competition Appeal Court had 7 cases. It's been able to finalize 4. And I didn't mention the statistics of the Supreme Court of Appeal. They finalized 214 of the 231 during this period of reporting. And additional to that, they had to contend with 1,062 applications, which were finalized out of 1,095. The Electoral Court has also lived up to its track record and done justice to its mandate of expeditiously finalizing cases that are referred to it, given their sensitivity and the speed with which circumstances almost always dictate they must be finalized. Reserve judgment, we've got a mechanism set out in the norms and standards through which they must be dealt with, and there is a report always with every head of court that relates to these matters. The norms and standards in the Judicial Code of Conduct regulates what is it that may have to be done depending on the progress or lack thereof in relation to these matters. So we also have, maybe I must read it, as part of accountability and in an effort to be transparent, the head of courts have taken a decision that a reserve judgment report containing a list of those judgments outstanding for 6 months or longer will be placed on the OCJ website. Any request for further information, such as the disclosure of information on the list of reserve judgments for individual judges or judgments outstanding for less than 6 months, must be referred to the head of the court concerned. Another new development in this report is the inclusion of key performance indicators for the regional courts and the district courts. I must thank my colleagues in the regional courts and the district courts for having taken it upon themselves to refine the performance, the key performance indicators so that they are in sync with where we need to go. We have not been able to attach the performance report because everybody knows that the magistracy have got a virtually impossible task on their shoulders that seems to defy the possibility of speedily coming up with a report that speaks to how they have been performing over the years. But it is something we are working on, which we hope to share with you as part and parcel of this annual reporting. The South African Judicial Education Council, SAJE, has facilitated a total of 142 judicial education training courses, and covering a total of 3,068 delegates in the period under review. The training conducted including court annex mediation, case management, and skills relating to the management of children's court, criminal court, family court, civil court, and they also extended to competition law, cybercrime, maritime law, judicial ethics, as well as environmental crimes. And SAJE has also produced 2 monographs on judicial education. The stress on judicial officers as a result of the traumatizing cases that they have to deal with, rape cases, gruesome murders, and some extremely challenging divorce matters involving children, as well as some of these gratuitous attacks that people just take the liberty to level at the judiciary without any substantiation, have necessitated the establishment of a bespoke judicial wellness program. We have developed something that we are reflecting on. We've been in consultation with one of the top clinical psychologists to guide us in relation to how exactly to manage this. We have drawn from countries like Singapore and Australia, who have moved miles ahead of us in this regard, so that because this trauma and these challenges are given birth to by the work environment, it should not be left to the individual judicial officer to fend for himself or for herself when challenges come. And to be more inclusive, we are thinking of having this housed under the auspices of the South African Judicial Education Institute for as long as the Office of the Chief Justice does not serve the magistracy. We're still waiting for that process. It's work in process. So we're working on that. It's at an advanced stage. We can only hope that resources will be made available so that you don't have a situation where colleagues crumble under stress at work in circumstances where it was foreseeable and something could have been done about it. One of our priorities is, of course, the introduction of court annex mediation. We had a fully blown training program necessitated by a 90-year-old judge of the 9th Second Appeal Court, I think they call it, Justice Warren. He is sharp. He is loaded with experience. He doesn't use any walking stick. And we had the privilege of learning from him, not only in relation to how to apply a win-win court annex mediation program, but also how to come to grips with the fundamentals of judicial case management so that you can benefit optimally from it. A number of colleagues have been trained. We are about to send, or have already sent, just President Mlambo will tell, about 7 or 9 of our colleagues at great expense to attend a conference in the US so that they can see for themselves how these things are done. I raise it deliberately because every time judges travel, it's like it's something wrong. It's like it's corrupt. We're very responsible people, and we are not tourists. We want to learn more firsthand, like all other arms of the state do as and when it becomes necessary to do so. We are on the verge of appointing a highly skilled mediator to oversee the implementation of this program and the training of the trainers. I must say, we have a pilot project running already, both in the two Gauteng High Courts and the Magistrates Court, under the supervision of Judge President Mlambo and his deputies, Deputy Judge President Ledwaba and Mojapelo. Now, we have also decided that only trial-ready matters will be set down, and that would, of course, be after a proper pre-trial conference would have been held. We involving more and more judicial officers in the management of pre-trial conferences because of disastrous pre-trial conferences that used to be held in the past. Just to cite an example, when I was judge president, I came across a pre-trial conference minute where one lawyer had a pre-trial conference with himself, and he was asking himself questions and answering, and produced that for the purpose of having the matter enrolled. So because of the many absurdities that have a tendency to delay, we've decided to assume the responsibility of ensuring that this thing achieves the desired purpose. At long last, we have the Uniform Rules of Court amended, an initiative of the Judiciary, which was also, produced a draft actually, that culminated in what we have right now, to facilitate the proper implementation of judicial case management and court-annexed mediation. It took too long, which takes me back, Honorable Magwanisha and Honorable Deputy Minister, Honorable Deputy Speaker, and Honorable Deputy Chair of the NCOP. We know, that legislative responsibilities rest on Parliament. No contest. But the very reason that the rule-making process can never kick off without the involvement, the critical involvement of judicial officers, tells a story that you would do well to go back to where the situation was in 1965 when the Uniform Rules of Court were drafted. It was the judiciary at the time that had the responsibility to develop and finalize their own rules because they know what they need. The insistence on having an act as currently structured that gives the responsibility to draft rules on the executive defies the very purpose of ensuring that we change systems as speedily as is necessary so that the court can function with greater efficiency. We have to wait for years, sometimes even after the rules have been finalized, for the minister to sign. We are not looking for power. We are looking for a responsibility that will facilitate speedy and quality service to those who consume our services, the South African public. So please reconsider. Now, the Judicial Service Commission was established for the reasons you know well. Transformation of the judiciary, but also to bear the responsibility to deal with cases of misconduct against those of us believed to have been involved in acts of misconduct, rightly or wrongly. And a point needs to be made. The judiciary has never shied away from holding their own to account. Never. You may raise concerns about the speed, but nobody can legitimately say that when there were allegations leveled against the judicial officer, we kept on digging and diving as if we want to cover up for one of our own. Never. The result is most of the cases of misconduct referred to the Judicial Service Commission have been finalized. We only have a few that have been staring us in the face for a very long time, only because there was litigation. And I've got to deal with this issue because it keeps on coming. If there is something that would really be a blight on the record of the judiciary, it is their failure to move with speed in relation to certain cases of misconduct. There's no blight. Cases of Judge President Hlophe, cases of Judge Motata, cases of Judges Mavundla, Preller, Poswa, and Webster took long for good reason. There was litigation involved. And the notion that when a judge wants to litigate, somehow the JSC or the Chief Justice has the power to say, no, forget about the Constitution. When it says anybody has the right to have his or her dispute heard by a forum or a court of law and be decided in terms of the law, it does not apply to judges. It's a fallacy. It would be an illegality for the Judicial Service Commission or the Chief Justice to try to prevent any judge or any magistrate who believe that there is wrongdoing in the process of preferring charges of misconduct against them or processing those charges of misconduct against them to challenge. They are entitled to challenge for as long as they want to. You would recall that even judges of the Constitutional Court, who were supposed to be witnesses, challenged and delayed the matter further. So how do you blame the Judicial Service Commission or the Chief Justice? We have got to be blamed and criticized for everything that we were lawfully able to do but failed to do. Having said that, we hope to finalize the Mutata matter this week. One thing or another has been coming whenever we try to finalize this matter. I hope nothing will come out. We hope to dispose of the Preller, Mavundla, and Poswa matter this week. The one of Justice Webster is a bit of a challenge because of the medical issues involved. I can't say how long it will take to resolve the Judge President Hlophe one. There seems to be a number of challenges there, funding-related challenges. So, criticism that assumes that we could have but failed to expedite this process can in the very least only be a consequence of ignorance or frustration. Now, there have been allegations of corruption against us, against the judiciary. And some people believe that it was just a matter of either the Judicial Service Commission or the Chief Justice are approaching the banks of the colleagues involved and say, bring their bank statements, let me see whether the money that Twitter says entered their bank accounts did enter. It would be illegal. We don't have the power to peer into the bank accounts of our colleagues. That is why, in line with what the law allows us to do, we as the judiciary instructed the Secretary General of the Office of the Chief Justice to write a letter to the National Commissioner of Police to use his lawful powers to investigate this matter, including locating the faces behind allegations that the judiciary or certain members of the judiciary is corrupt. And we've received a response. The National Commissioner says he has directed the Hawks to deal with the matter. I know that Mr. Rahube presented a document to me at the press conference we had on the 13th of this month. I also know, and I was shocked to see a heading on a poster coming here from Mogoeng on Wednesday. everywhere almost. SA judges misled to facilitate de facto money laundering, UK claim. That is based on what Mr. Rahube said and on what Mr. Lewis said. Mr. Lewis is a farmer from the UK. He says it himself that he's not a lawyer. He, among other things, approached me to say I must now give authority to Lord Hayne to investigate judges of the KwaZulu-Natal Division of the High Court and of the Supreme Court of Appeal. I must subject judges to some Magitsky, I think something like Magitsky Act of the United Kingdom. Please, any well-meaning South African, read the document of Mr. Rahube. Read the document of Mr. Lewis. I am shocked beyond description that any newspaper could find it acceptable to publish a story, a baseless article, under such an extremely damaging heading. Because those who did not read the article to see its emptiness for what it is, and have just seen the posters, went home saying, there they go again. Now they've moved from sheer corruption to the facilitation of money laundering. Any South African who cares about our constitutional democracy, any South African who cares about the future of our children, we say to you, we are not perfect people. We are not a perfect institution. And we ought not to be immune from legitimate criticism. But this gratuitous criticism, as if there is a campaign to delegitimize the judiciary, so that when they make orders against you, you can have the opportunity to say, this is an order by corrupt people. This is an order by facilitators of money laundering. How can I be expected to obey this order? It took this institution, we say it with all sense of humility, to intervene when it matters the most. And I urge every South African who cares about this country and its future to make it his or her business to wake up and deliberately confront any baseless accusation of corruption in the judiciary. What did we say? We said anybody with the evidence must come, so that if there are rotten apples in our midst, they can be kicked out rather than spoil the reputation that we have worked so hard to build as the judiciary. What do we see? We see Mr. Lewis, who is unhappy because the way the court interpreted the evidence is not satisfactory to him. He is not saying any particular judge is corrupt. He is not. We have Mr. Rahube. What does he say? He says he suspects that the documentation presented for the adjudication of his case may possibly be tampered with by the registrar or other officials of the High Court. We were asking for evidence of corruption against the judges. Where is the evidence? So if anybody has evidence, all we are saying is we are begging you to present it, and feel free to even publish it before you give it to us. That's how confident we are that we don't cover up for the corrupt. Sexual offenses or gender-based violence cases require an integrated approach by all key stakeholders. And what follows are some of the measures that could alleviate the problem. I think we need an awareness campaign, an informed awareness campaign to the general public that says, we know that there's been a lot of humiliation, there's been a lot of discouragement that came with reporting these kind of cases. These are the measures, the practical steps we have taken to alleviate that humiliation or that encouragement. That public awareness campaign must also include how to report and focus. I beg your pardon. It must include how to report on these cases, and the assurances given must be demonstrably credible in relation to the processing of those cases. What we also need, I'll just run down these things. I think you need a focused and well-trained cohort of investigating officers that deal either exclusively or primarily with gender-based violence cases or rape cases. We need to know that these people have the training, because these are very sensitive matters. It is not just any investigating officer or any police person who would have the capacity to do justice to these matters. So that capacity must be injected into that unit or that group of investigating officers. In other words, we don't have to reinvent the wheels. I believe that there are police people elsewhere in the world who have those capacities, who have those best practices that we can inject in our own system. The reorientation of all front desk or church office functionaries to sensitize them to the better and more appropriate handling of these cases is critical. I'm glad, Honorable Sylvia Lucas, I heard you articulate that point, but that was after I had included it already. Now, what I found to be particularly rewarding for these kind of cases and other complex cases is to be found in the French system, although it's different from ours. What the French police, I had a very serious meeting with their top officials. What they do is, they have police officials and magistrates, specially trained magistrates, working together in the investigation of cases. And it extends to dealing with admission of guilt cases. If the matter goes to court, the magistrates don't have to be involved. Let me just make the point. I know people tend to gravitate towards the best practices in legal systems that are similar to theirs. You don't have to. The Chinese system is fundamentally different from ours. But I can tell you there is a lot to learn there. There are fundamental differences with the German and the French system, but there is a lot to learn from that, even in relation to judicial education training. So the measure of highly trained people like magistrates with practice, who would be working hand in hand with the police, even with the possibility of complainants reporting to them at all times, is critical if justice is to be done to these cases. They will be speedily investigated with appropriate guidance. You may even want to dedicate prosecutors there instead of magistrates, but whatever you choose to do, you need a lawyer with a lot of legal practice involved in the investigations of these matters that have really given us a lot of stress. Prosecutors must also be specially trained. It's not just any prosecutor with experience who can handle these cases. Just as the SIU have specialized people there, these cases are of such a nature that they also require special training. People must be specially equipped. They must have the expertise, the sensitivity, the professionalism, and special competence to handle these matters. Judicial officers must also be specially trained to handle these matters. Intermediaries and interpreters. We have struggled with intermediaries for a very long time because social workers were at some stage, I don't know now, the worst paid public servants. So the best were always taken by the private sector. I hope there has been intervention. I hope there is a deliberate plan in relation to the orientation and training of intermediaries and specially trained interpreters for this kind of sensitive cases. You don't just speak anyhow. You must be specially trained and possess the sensitivity that is necessary here. I think a revitalization of Tutuzela centers is important. They used to do such a good work I don't know what happened. Let's go back to them and make sure that they function as well as they are supposed to function. Domestic violence, you need a very sensitive and more responsive approach to them. Special training, appropriate facilities, because most of the time, Minister Delil, you'll find that you are here, you are sharing your secrets with the person who is supposed to help you. But there's no space to keep others away from your privacy. Everybody is overhearing what you are saying, even possibly those who may give information where it is not supposed to be given. Key role players in the justice system, particularly in relation to gender-based violence cases, have not been working together. And they've been working in silos. I believe, Deputy Minister, a lot of good work would have been done had the judiciary at all levels, especially the leadership of the judiciary, been involved in working on the sexual offences court. But there hasn't been consultation, at least not with me, in relation to the re-establishment of the sexual offences court. I raised this concern in the past with the previous minister to say, you can't just launch a court. It is not about the building and the equipment. It is about the capacity of the police, of the prosecutors, and the magistrates who are going to handle these cases. Have they been trained? Have you increased the number of prosecutors and the number of magistrates who are going to deal with these cases, because they have not been coping with the work that has been available? And I had an engagement with my colleagues in the magistracy about it. I hope the situation has since changed, because I don't know what has recently been involved in the establishment of these courts. In case you are surprised, that is why I wasn't even involved or present at the opening of the Boysen Court, because I know nothing about it. We need to work together and forget whatever our differences may be for the sake of the victims of these crimes, whatever it will take for greater efficiency and effectiveness to be injected in the system so that the people are better served. That must be allowed to happen. Whoever is the ultimate decision maker can then decide what he or she is going to do with the information that has been given to them. All we are asking for, because when criticism comes, it doesn't leave out the judiciary. All we are asking for is consult us, and consult us meaningfully. I saw the rules recently. I agreed to them and indicated the need for greater consultation. Happily, Minister Lamola and I have had a very deep discussion, and we have a common understanding in relation to how we can best cooperate on issues that affect the functioning of the courts going forward. It is as a result of that cooperation that he was gracious enough to call me on Monday to tell me about the challenges he have in relation to attending this meeting. But he will certainly be attending the heads of courts meeting tomorrow. That's the promise that he has given me. So I think we need to be working together now more than ever before. And let me say this. The imposition of harsh sentences is one of the deterrents. But all of what we do is addressing the symptoms. The court systems, the police, and the prosecuting authority only address the symptoms. We still have to have a deliberate plan to deal with the root causes of these problems. Why does somebody find it possible? A 40-odd, 60-odd years old person to rape a 6-month-old person. 6 years, 89-year-old. What is going on? Magistrates have been imposing harsh sentences on these people. Check the record. They have not been lenient. But why is this going on and on and on? I think we need to diagnose the problem correctly so that the medication we dispense for the problem would be effective and help us to either reduce this problem significantly or to cut it out. Our engagements, by the way, with colleagues where there is unmistakable peace and stability and where these crimes are not as rife as they are in our country, in Germany, in France, in the Netherlands, and Norway, said to us, I was asking them, why are your sentences so lenient? I said, it's not about the harshness of the sentence. It is about the predictability of detection, the predictability of effective prosecution, the predictability of conviction when the evidence is available. It says, but when people think your system is sick, it lacks the capacity to do what it was established to do, they take their chances. So we need to do a lot, as I indicated earlier, to strengthen these bodies so that they can achieve what needs to be achieved. We have given or circulated the balance of this speech. I need only say we've taken measures, as I indicated last year, to cut down on costs. We've appealed to colleagues to reduce the level at which they pitch their official vehicles to way below 1 million. The overwhelming majority of judges have been very, very supportive, but we still have those who insist on very expensive vehicles. Our position is it's a matter of conscience. If you insist on a very expensive vehicle, notwithstanding the dire economic situation in which the country finds itself in, well, that's your problem. Minister DeLille, we're very grateful for your timely intervention whenever you are called upon to do so. The Deputy Chief Justice and I are beneficiaries of your conscientiousness and the deliberate speed with which, when contacted directly, you are willing to intervene so that the needs that we have are met. I must make the point, there's a very serious problem with your department. It's almost as if we must beg the public works officials to do what they were appointed to do what they are paid every month to do. It's known by everybody. I'm yet to come across any department in this country that is satisfied with the performance of public works. And when you tell them that the service they want to provide is too expensive, you can't reconcile your conscience with what they want to do, they get angry and withdraw services from you. I think public works must enjoy special focus. This thing is an embarrassment. It's been going on for too long. We are just talking about it. There doesn't seem to be any consequence management. Courts are suffering because though we have established a structure at which we can meet with them peacefully and respectfully to address the issue, the National Efficiency and Enhancement Committee, they don't even come to meetings. They will promise to come. Judge President Mlambo is here. He's the chair of our Infrastructure Committee. They will promise to come and not come. We are not begging Public Works and Infrastructure Department for anything. Like us, they should consider it an honor and a privilege to be allowed to serve the people of South Africa and be paid. Consequence management that has real teeth must be introduced in your department. So with a good, I hope that you will continue, and I hope that those who don't deserve to be there will be appropriately and speedily identified and taken where they deserve to be. I want to express, finally, my appreciation to the Secretary General of the Office of the Chief Justice, Ms. Mmese Josengwe, and the officials in that office for their commitment to ensuring that the right thing is done. I also want to commend my colleagues who have been assigned the responsibility to work closely with the Office of the Chief Justice to make sure that nothing that is contrary to the prescripts and the law is done. We took a deliberate step as the judiciary, and we announced it, as I'm repeating it here, that no judge, regardless of the position they occupy, must be allowed by members of the Office of the Chief Justice to do anything that the prescripts do not allow them to do. This thing of by word of mouth giving instructions, when trouble comes, hiding behind that these people are supposed to know their responsibilities when you were in fact pressurizing them to do the wrong thing, is forbidden in the judiciary and in the Office of the Chief Justice. Therefore, before I even lift up the report that we are here for, here is the report of the Office of the Chief Justice. They have received a clean audit as a national department, because we wanted to make a point as the judiciary that you can be in government and still be effective and efficient and be ethical in the way you go about your business. So congratulations, SG and your team, for a job well done. And here is the report that we are all here for. And now we will be, with the facilitation of the President of the SCAB, taking questions. I must say, any question, even if you want to ask questions relating to those emojis that you are sending in relation to corporal punishment, you are free to ask those questions.
Thank you very much, Chief Justice, for that very enriching address on the performance of the judiciary of our country. I have no doubt that we are more enlightened now than we were before about the performance of the judiciary. Of course, there is more that you will find when you read the book that the Chief Justice showed all of you. I heard that the Chief Justice was offered 600 million rand. This figure is not unfamiliar in my ears. It looks like certain figures are popular. Those who may have been followed the proceedings of the commission that I chaired in the past few days may have noticed that there was a figure that kept on being mentioned quite regularly, to the extent that I remarked within a certain law enforcement agency that some of the people involved in that agency liked asking for 40,000 rand and paying 40,000 rand. So it looks like certain figures are popular. Thank you very much, Chief Justice. I think you have highlighted a number of issues that are quite important. I just want to mention one or two. I think the point you made about the conviction rates being used to assess the performance of prosecutors is indeed a very important point, and I have myself been very concerned about it, because a prosecutor's job is not necessarily to get a conviction. It is to present evidence before the court to the best of their ability, and if there is enough evidence, the court must convict. If there is not enough evidence, the court must not convict. And if you are going to say, if there are few convictions, it means the prosecutor is not doing his or her job. That means the prosecutor will then start trying to get convictions at all costs, to the detriment of justice. But also you made a point, Chief Justice, about how the judiciary treats their own when they have got to decide matters involving judges. It is true that the evidence that is there is quite clear. When judges deal with cases involving other judges, they deal with them properly. The law reports have got reported judgments where judges have been litigants and their colleagues decided matters, and there are cases where they decided against them. Our law reports even have a case where justices of the Constitutional Court had to decide a case involving a Chief Justice. And judges deal with those matters properly. There is no attempt to try and cover up. I chair, at the request of the Chief Justice, the Judicial Conduct Committee, which looks at complaints against judges. I know of no judge who thinks that it would be right that when the judges who sit in the Judicial Conduct Committee deal with complaints against them, they mustn't do their job properly. They must do their job properly. And if the complaint has a proper basis, that's the decision that will be made. If the complaint has no proper basis, that's the decision that will be made. We subject ourselves as the judiciary to these processes, and we do not ask for any favorable treatment. So I thought I would just mention or highlight my perspectives in regard to those. At this stage, we are going to have a question and answer part of the session, as the Chief Justice indicated. It will be facilitated by the President of the Supreme Court of Appeal, Justice Meyer. I am going to now invite her to come forward to facilitate that part of the session, and she will announce how she will deal with it. And my sister, please come through.
Thank you, Deputy Chief Justice. Chief Justice, colleagues, distinguished guests, good morning. It is still morning, yes. I shall now take questions from the guests, and this gives you an opportunity to ask any questions you may have on the keynote address that the Chief Justice has just delivered, and any questions that you may have on the manner in which our courts are run. And as the Chief Justice has already indicated, you have carte blanche. There will be no holy cows. May I just first announce a few before I do that, MP Ms. Patricia DeLille left the proceedings, and the Chief Justice just asked me to inform you that she had previously asked for permission to be excused early. She was not being rude. Housekeeping rules. 1, just a reminder to members of the media that they are not allowed to take questions at this session. They will get an opportunity to do that elsewhere. 2, a plea to those who want to ask questions to please keep them as concise and clear as possible so that you may get an equally satisfactory answer. And 3, you will raise your hand to indicate that you want to ask a question. Shall we then start? Just one. All right, I have noted you, sir. Anyone else? You too? Anyone else? All right.
Thank you very much. Thank you very much, Chairperson of the session, the Chief Justice, the Judiciary, Parliament, and every stakeholder that is here. I'm a member of the National Assembly, representing the ANC in the Justice and Correctional Services Committee. We trust you, Chief Justice, that you always deliver a very resounding judicial sermon whenever you are given an opportunity. Chair, I wish to indicate this as a question. I want to ask about emojis. In the corridors of society, there is a huge support to the popular commission, Judge Zondo, that it is one of the means by government to outroot corruption, in particular into the public sector. But what has raised an alarm is the accumulating amount of money that is being used and the dragging of the process of the commission in resolving what it is tasked and mandated to do. The second one, Chair, the actual question is that with regard to the work already done by the commission, when do we think that we can quickly conclude the mandate of the commission? Another question, Chair. Just allow me to draw you back a little bit. In the last annual report, when you said Chief Justice, this is a platform where you come and account into where are you as the judiciary in ensuring that you bring access to justice for our people and actually speedily you deliver justice to all our people speedily. In the access to justice concept, firstly, despite the fact that we know that a number of people within our broader society are unable to afford the private legal practitioners to represent them into spaces of the Supreme Court and others. And equally, it is a known fact, Chair, that the legal aid South Africa has got limited resource to that effect as well. Now, how do we then ensure that you as the judiciary, you speedily bring down to the people access to justice in the form of, because, Chair, judging from the number of Supreme Courts which are in some of the provinces, the distance of jurisdiction is quite long for others to have access to services of the High Court. If I may make a few examples, Chair, a person from Bizana in the Eastern Cape who's under the jurisdiction of the Mthatha High Court. A person from Komani in the Eastern Cape who is under the jurisdiction of the Grahamstown High Court. Just few examples. How is it possible, if it is not done yet, that we are able to take the sitting, whether it's periodic or something, the sitting of the Supreme Court to, whether it's chambers of various magistrate courts, so that we take the Supreme Court sitting closer to the people where it is mostly needed. Lastly, Chief Justice, I have received a text while sitting here regarding the recent judgment on spanking of children. The text is saying, Mr. Ngola sicela usibuzele ku-Chief Justice. Manje mbethe abantwana masingababethi. Uthi xa bemosha sibathini sibase kwakhe. But immediately, Chair, that signal that there is a dire need for a thorough explanation to society that how has the Constitutional Court arrived into such a decision? What are the basic legal reasoning behind the decision of a non-spanking society? Thank you very much, Chair.
Mr. Ngula, is it? Ngola. Your question has 3 legs, according to my count. Perhaps I should give the Chief Justice and whoever he chooses to answer the questions to come to the lectern.
I think it will be best to start with the last. Honorable Ngola, I assume you've read the judgment. Because if you had, all the reasons are there. You see, those who have not read the judgment, for one reason or the other, can be excused for assuming that we have the possibility just to say, to spank or not to spank. No spanking. Without regard to anything of consequence. Here is the bottom line. The Constitution of the Republic of South Africa is the supreme law. Therefore, in the adjudication of cases, it is what the Constitution, the law, and the facts point to that all of us are constrained to do. Let me explain it. I am a Christian, a born-again Christian who makes no excuses for his faith. You can mock me all you want. You can even think I have fallen from grace. That's your problem. But when interpreting a case like this, I had regard, for instance, to scriptures in the book of Proverbs that speak to the need to not to spare the rod. So it's some kind of a dilemma, isn't it? But I took an oath. And my oath of office says that I will administer justice in terms of the Constitution, all laws of the Republic, the human rights in the Constitution, without fear, favor, or prejudice. So when a combination of the Constitution, the supreme law, the facts before me, including the compilation of expert reports, is before me, what choice do I have, but either to follow the dictates of the Constitution, the clear language of the Constitution, or resign. Resign on the basis that, there are now cases coming that don't allow me to be the kind of Christian that the Bible says I must be. So, let me rather quit because it looks like this is a court for unbelievers. I can't. account, I knew what the laws of South Africa stood like when I agreed to assume this responsibility. It was not a pursuit of some prestigious office so that you can have a better salary or you can be mentioned from time to time whenever there is a gathering. No. It's a humbling responsibility that requires an unmistakable commitment to the necessary ethical standards. It requires a solid character and integrity to execute it well. Just as my colleagues who in the first case, the Makwanyana case, knew that the overwhelming majority of South Africans prefer the death penalty, looked at the law, said, but what does the Constitution require of us? But what does the public want? Are they perhaps going to condemn us left, right, and center for doing what we know they don't like? They had to be people who espouse intellectual integrity and say, well, the Constitution points in this direction. The evidence points in this direction. That's where we were, by the way. We didn't just without an appreciation of the preferences of the public. I suspect, and that's a personal suspicion, I suspect that the overwhelming majority of South Africans prefer the retention of reasonable and moderate punishment. But what does the law say? And what must the public do? If the overwhelming majority of South African citizens prefer that moderate and reasonable chastisement be retained, they must cause the Constitution to be amended to say what they prefer, so that we don't get blamed for the Constitution that we did not write. We can't rewrite the Constitution. We can't. So have the Constitution amended, we will interpret it as amended. That's the solution. And I can't emphasize enough, please read the judgment. I've seen people supporting the judgment, others opposing it, who clearly did not read the judgment. Because the reasons advanced in support or against are those of people who have never read the judgment. Read it and criticize it from an informed basis. Supreme Court Supreme Court sitting closer to the people, it is the responsibility of Parliament to do that, Honorable Ngola. We can't just say, all right, the Constitutional Court will now be sitting in Galeshewe tomorrow. We don't have that power. Neither does the Supreme Court of Appeal. But at the time when the 17th Constitutional Amendment Bill was piloted, there was an attempt to have the Supreme Court of Appeal sit periodically in the different provinces, but that was defeated. And the judges didn't quite support that as well. So let's debate it and see how best to make justice accessible to the people. But I don't think it can work at the Supreme Court of Appeal level. And finally, Honorable Ngola, the High Court takes its services to the people. The Labor Court takes its services to the people. The Land Claims Court takes its services to the people. The Magistrates Court, regional and district, take their services to the people. There are even periodic courts to go where the people are so that they can have access to the services they need. The reason why we have introduced court-annexed mediation is precisely to make justice accessible to the people. That is why we are even saying it is wrong in our view to introduce court-annexed mediation and say the public must pay for it. Because it is designed, even where it is properly practiced, like in America, to make access to justice cheap and easier. So, train magistrates, train whoever, but let the state bear the responsibility to pay those who are mediators. So we've done that, but there is more. Apart from distance, I was in Idujwa, for instance. I had a meeting with a kin there, and I have seen the distance between the court and the village, and I'm aware the transportation from Idujwa to the nearest magistrate's court is just impossible. The roads are lamentable. And we had a very deliberate engagement with His Majesty. Part of what I said to them, and I'm not apologetic about this, is I believe that traditional courts can be restructured to be constitutionally compliant so that they can make justice accessible to the people, especially in the villages, in terms of the laws and practices that they understand. I don't accept this notion that the traditional courts are automatically discriminated. Why can't they be restructured? The same way courts that used to be used by some as instruments of oppression to the majority have been successfully restructured. So let's work on the traditional courts and make justice accessible to the people. Train the traditional leaders. We have taken it upon ourselves, by the way, as the South African Judicial Education Institute, to offer training to the traditional leaders. Ask them, they will tell you. We've been moving from province to province to train traditional leaders so that as they apply these laws, it is not in a manner that is in conflict with the Constitution of the Republic. The Zondo Commission. I think I need to be blunt. I perceive that some in society are against the Zondo Commission and would like it dead, like yesterday, for a number of reasons that I wouldn't like to go into. And I pose a question. Which budget of which commission are we comparing the budget of the Zondo Commission to? It's important, Honorable Ngula, to appreciate this one point. Just last week we had the report of a commission of inquiry that they have been investigating for 5 years, 9 months. The Zondo Commission has not even entered 3 years, but we are already complaining. Why? Why? What are we afraid of? What damage do we think the Zondo Commission is doing for us to stingily approach the funding of the commission? Why are we complaining? I can see I saw a particular article in one newspaper complaining. And I said to myself, more is coming. There appears to be a well-orchestrated plan to undermine the operations of the Zondo Commission because too much is coming out. We said we are against corruption. And if we truly are against corruption, let us allow this commission to uproot corruption. Let us support what the commission is doing. It doesn't use money yet. There is a commission that took 4 years investigating. Who was complaining? Why are we singling out this commission for concern? I think the public must be encouraged to be particularly curious about articles and some sidekicks against this commission.
Thank you very much, Chief Justice. We'll take your questions, sir.
Thank you. My name is Tilibali Muraudzi.
Mahotsi.
Muraudzi.
Muraudzi.
Yes, I'm a member of Parliament serving on the Portfolio Committee of Justice. So I would like to first appreciate the presentation by the Chief Justice, the presentation which is clear, precise, detailed, and touching. And also to appreciate the 600 million private funding you rejected. We are happy because you have foreseen the capturing coming when it was still far. And I hope also the ministry, the deputy minister is not here, the ministry will also advise the minister, because they are on the process of getting private fund to fund the NPA. And we don't know who's that funder who's coming to fund the NPA. So it's a concern to us for the private funding in our judicial system. The issue raised about more cases and less judges is true, and the ministry will discuss it in our parliament to do our part, so that the department, as we oversight over it, to allocate a budget to have more judges or more presiding officers in order to avoid the backlog. So the question is this one, the Chief Justice. There is a court directive, which is now normally called Practice Directive 2 in the North Court, High Court in Gauteng. So our concern is, why is it's directed to the poor victims? Because that court directives is only specializing for the matters of road accident fund. The PRASA, people who got the accident by trains there. The MEC of Health, our public hospital, only in Gauteng. So, and when we check the victims, the people who are making the litigations, we found out that the majority of them, they're the poor of the poorest. And now as we're talking, we have 6,000 outstanding cases of road accident fund. Again, 80% are poor. On the desk of the Deputy Judge President, Lidwawa, which are not yet allocated. Some of the cases, they are as far as 5 years waiting without the allocation of a date. And again, we have this new Practice Directive 2 for the special cases. If you are the victim of the private hospital, like Bonnet Care, you can litigate anytime. And the people who go to the net cares and the medical clinics, they are the rich people. The poor, they go to the public hospital. And when they claim, they must wait for 10 years. So why are we focusing this directive to the poor of the poorest? The second question is about, do we have any measures, Chief Justice, for the public members to present their complaints to the JSC, like a hotline for the whistleblowers who want to be not known, but they want to give the information to the JSC, not to be victimized? Do we have such measures in order to assist the people who are members of public to lay their complaints to the JSC? Lastly, it's true, Chief Justice, our nation is sick, and we need God to intervene in the life of our nation, because you can see what is happening. A normal man age who can rape a child with napkins. We are sick, and it's true, and we need God intervention. Thank you.
Thank you, Mr. Morawuti. The gentleman in front of you.
Thank you so much. My name is Stephen Swart. I'm a member of the Portfolio Committee, and I'd also just like to thank you, Supreme Court President, for presiding over this issue. Thank you, Chief Justice and members of the Judiciary, for the report. Our challenge, obviously, as members of the Portfolio Committee is we haven't engaged with that yet. We've just received it today. So I would like, Chief Justice, for you to consider a mechanism where we can engage with Parliament, where we raise matters of mutual concern in respect for one another. We've done it in the past with meetings, and I think that is something we could continue in establishing some issues. But just one or two of the matters, and of course I would like to commend the Office of the Chief Justice and the Chief Justice for the clean audit. I also sit on the Finance Committee, so I am very appreciative of that. And I'm fully appreciative of the financial constraints under which the judiciary operates. And we appropriate the budget. We can amend the budget within the fiscal framework. And if proper matters are presented to us, then we can approach the Finance Committee, the Justice Committee can approach the Finance Committee and the Appropriations Committee. And being a representative of a smaller party, I sit on all those committees, so I can be of assistance. But what I would like to just, on the one or two issues, I want to just touch on what Advocate Molutsi said, the nature of our society and the need for God. I represent the African Democratic Party, and I thank you, Chief Justice, for stating your faith. And it's a deep spiritual answer. It's something we need in our nation. The malaise we're faced with, we need a lot more prayer, interfaith, with a lot of people coming together and praying for our nation. But just directly on issues relating to the judiciary. Chief Justice, you mentioned the spanking issue, and I have read the judgment. And I think what is important to mention is you also relate in your judgment to a paucity of evidence that was presented before you. Now, we as a party have expressed our disappointment, we respect it, but we do also appreciate your limitations. What I would ask you, though, a broader context, is often the Constitutional Court will find the need to strike down legislation and refer it back to Parliament. The process goes via the executive. The process is inordinately long, which might, and I'd ask you whether this is in fact the case, result in the judiciary having to read in provisions in the view that this will take such a long time for the executive to present an amendment and Parliament to finalize. I would think there might well be cases where that is the case, but that I'd ask you to comment with. In this particular matter, the spanking matter, you raised the issue of Parliament having to take some steps. And whilst I respect the judgment, would it not have been necessary possibly to refer the whole matter to Parliament, understanding, of course, that we drafted the Constitution. And at the end of the day, if blame must be placed for, or if you were to disagree with that judgment, it is because we drafted the Constitution. And you correctly point out the answer would lie in an amendment, but I think a lot of people don't look at the other issue you raised, and that is the de minibus rule, which you also referred to, where the law does not involve itself with trivialities. So, Chief Justice, and ma'am, thank you for that. Also relating to the North Gauteng court matter, I think that is, we appreciate that it is in the hands of the judiciary. But what concerns me when it comes to accountability of the judiciary is the Chief Justice indicated that it will only go from the point of enrollment on. Now, we know there can be delays running up to that, involving other role players. And I'd like Chief Justice to comment on that, because we have people approaching us, our constituents, that are saying, this matter is taking too long. And now what Advocate Molutsi has referred to, some of those matters are going to be delayed for 2-3 years. And there are large numbers. And I understand the issue at the North Gauteng court, where almost the judge president and the deputy judge president are being, to a certain degree, undermined by staff, that it is with files getting lost and a lot of issues that are beyond their control. And I'd like your comments on that. So thank you for allowing me the minute or two to comment on that. Thank you so much.
Thank you, Mr. First, Chief Justice.
Thank you, President. Thank you, Honorable Mlauzi and Honorable Steve Swart. Let me begin with the Road Accident Fund and these medical malpractice cases, I assume they are. Here is the problem. And I'll allow Judge President Mlambo to say something if I have missed out on something of importance in my responses. There has been this problem in relation to the Road Accident Fund. However straightforward a case may be, let me conclude that statement. It will take too long to have any progress made in that case. That has been the trend. What would then happen was, even when there is the time now for a pre-trial conference to be held, the lawyers for the Road Accident Fund won't come. And even when there is a possibility, a straightforward possibility to settle the matter, so that the road accident fund that is almost cash-strapped does not spend unnecessarily on the lawyers, instructions would not be given. Now, but in the meantime, a date would have been given to the lawyers. What then do? You allocate the whole week or more for that case to be heard. Only when the lawyer arrives in court do they say, no, we have settled. Why? To build up a bill, to make sure that there is a lot of money that will be paid to the lawyer at the expense of the cash-strapped road accident fund. And what is the ripple effect of that? The ripple effect of that is the road accident fund is not able to pay claimants who desperately need payment from them. We have had very serious and deep engagements with the executives of the road accident fund. They were even pleading with us to come to an arrangement in terms of which not everything should be paid immediately, because they just can't cope. They don't have the money for that. And most of the money goes to the lawyers, or consumed unnecessarily by this process. 2, we have intervened even more, and it makes many unhappy, because we have realized that the way this contingency fee thing operates, and the reason why people insist on immediate payment of everything, even if most of the money will only be needed in the future, for instance, is for medical treatment. I mean, you don't get treated today for 2050. Why can't the money for 2015 come then, particularly if the state doesn't have the necessary resources? So for the computation of a fat fee, you must now compute this on the basis of this huge amount of money, even the money that will only be due in the distant future. Why should it be like that? So we are trying to intervene to manage this thing carefully, but we have realized that the problem is not just with some lawyers. The problem is also within the road accident fund itself. There seems to be something cooking between some of the officials of the road accident fund and some of their lawyers. So what I understand the judge president to have done, which is what all other judges presidents are doing in relation to these matters, is we are not going to enroll the matter unless you have done what is necessary to get the case ready for hearing. So that if you have got no case, you don't waste court time by having us enroll the matter that can be easily settled to the benefit of everybody. And my understanding is it was the abuse of the system, the abuse of the process that Judge President Mlambo was seeking to curb. Well, he's nodding. I didn't discuss it with him, but having been Judge President before, I know what is involved in this thing. The same extends to the medical malpractice cases. What has been picked up, and we discussed it at the heads of court meeting, is that a claim which common sense suggests could really be settled at just a rough figure, 3 million rands. There would be an agreement between the Department of Health and the people from the other side that it must now be settled for 300 million rand. So we have conscientized ourselves about this, but there's something wrong here. We have got to be satisfied. This is government money. This is the taxpayers' money. And we cannot just be taken along because people say by agreement between the parties. We can't. It would be irresponsible of us. So we've got to interrogate the justification for paying experts as much as it is said they are supposed to be paid, the justification for paying other people as much as they are claiming, vis-a-vis what the one who has really suffered is receiving. Because there's some notoriety about these cases. You had a situation at some stage where what the lawyers get and what the experts get could give you a false reason to believe that they are the ones injured and not the victim. So we have a responsibility as the judges to satisfy ourselves that only the correct amount is paid and is paid to the right person, and nobody builds up a bill at the expense of the process while we are watching. So I'm sure Judge President Mlambo is open to further engagement with all the people that are concerned, but it is a pure motive that informs the reason why the directive had to come, to make sure that nobody abuses the system and that there is expedition. I need to make this one last point on this. We took a decision that some matters deserve to be expedited. And some of those matters are road accident cases as well as the medical malpractice cases. They must be fast-tracked. There are some of those matters that the head of court must deliberately make sure that everything possible is done to speed up their finalization. That is why we insist on credible pretrial conferences to make sure that they are speedily managed to finality. But there hasn't been cooperation from the legal representatives of those people. And in the absence of cooperation, there is nothing that we can do. It means it is the parties, unfortunately, unknowingly, through their legal representatives, that are delaying the matters from being finalized. So, let me jump to another thing. In relation to that complaint, in relation to the need to report judges, please don't hesitate to complain about these things because we get embarrassed. Sometimes you get to know that judgment has been reserved for 6 years, when people should actually have told you in advance as the head of court or as the Chief Justice. Fortunately, we now have a system in place. So, the easiest way to communicate is to just know the email address of the Constitutional Court. You just add the name of a judge, and then it's concord@concord.org.za. We receive emails regularly, Honorable Member, you may know. Hey, people are insulting us. We are used to they insult properly and regularly. So that's how easy our email address is. You just send your query to us, I'll find it, I'll see it. And if I do nothing, or nobody does nothing about it in the office, you must insist on being attended to. The Secretary General, we had said you people will give me the address, the website. Is it in the speech? Okay, at the bottom of the speech, is that the one? So that's how to communicate with us and lodge whatever complaint is there. Now, I think I've touched on the Honorable members' issues. What then remains is Advocate Swart MP's issues. We want to have that reflected, Honorable Swart. As I indicated in my address, we are starting. We are starting to build an infrastructure. We are starting to put a roof on. Some of the things we consider to be furniture, however critical it may be. We'll get there. We're very much alive to the fact that before we introduce, for instance, judicial case management, in busy jurisdictions like Gauteng, it would take as long as 3 years before your case is enrolled. And we know we've brought it down because of the implementation of judicial case management. What we haven't done was to provide statistics to demonstrate how that period is to be managed. Here is part of the challenge. Which case are we going to mention out of the what? Are they about 15,000 or let's say roughly 17,000 cases that we receive? Do we mention the entry point of each manually, the entry point of each in a report? from that to enrollment? Or do we come with an average? It's a laborious task, and we believe that the introduction of court automation will make that easy. But at the moment, just imagine how huge the report was going to be, because we were going to have to itemize them and say this criminal matter, this civil matter was lodged this time, because you can't rely on another matter to determine when another was lodged. So it's a huge task. We are alive to the sensitivities, but we thought it was necessary that we do what can be done at the moment with the resources at our command to show that we take seriously the concerns that are out there. And of course, as I indicated, it depends on the budget. We are deeply worried that our budget, like the budgets of other departments, get cut without any consultation with us. We believe it can only be proper for the judiciary to be consulted whenever the need arises for its budget to be cut. It does no harm, even if you ultimately cut it, but at least extend the courtesy to us to say we have serious financial problems, we need to cut your budget. But just to cut it like that, I don't think it's proper. So we are begging for meaningful consultation before that happens, because it tends to undermine critical services that we have to render. As for a mechanism for engagement, it is true. We've just given the report to everybody, including honorable members of parliament. We have a system. I'm waiting. I was told members of the portfolio committee have a number of issues that they want to raise with us as the judiciary, and we are ready. I was led to believe by the Secretary General that the Honorable Chair will write a letter asking for a meeting so that we can have a meaningful engagement. We are ready and waiting, because our position is, just as we have to enjoy judicial independence, we are not self-employed people. We are employed by the people of South Africa. We are paid to do what we do. We must account for what we do. So as soon as we receive the request, we will entertain it so that there can be more meaningful engagement. And finally, on the issue of decisions going past the executive, I'm not aware of any law that says it must happen that way. I'm not aware of any law that prevents Parliament from accessing a judgment of this court and doing what it is required to do with it. Remember, the Constitution says even Parliament, the National Assembly, can initiate legislation. So nothing forbids Parliament from taking the initiative of making sure that the delay is obviated by running with the process that requires attention.
Thank you once more, Chief Justice. I will take the next round of questions, starting with the lady in the back row, third from the, yeah. No, did you?
Dumela. My name is Mamora Hololo, and I'm going to speak as a lay person because things are so deep here, but I'm a member of civil society. So there are issues that have been mentioned here, and I just want to have an understanding. I am also a pastor. I heard the Chief Justice speaking about their education, also educating the traditional leaders. Now, I wanted to find out how possible is it, because as a member of the community and the civil society, we are dealing with a lot of people on justice matters, but we have no idea. So the very same education that is being given to the traditional leaders, I don't know how possible is it. Can it also be given to the churches, because we have infrastructure? Like now, I'm a member of faith-based organization. We have partnered with South African police called Divine Intervention, where we are dealing with issues because we know what is happening in our communities. So we'll be receiving some of the information from the communities. Like the other time, one person said to me, we can use the pro bono lawyers for other issues. But when you go to, I think it's here in Constitutional Hill, when you get to the department, there are so many queues, and they tell you that for the next, I think, 6 months, there won't be any pro bono lawyers because of the backlog. And then now you are looking at prescription of the case of the person that you are trying to help. So I'm trying to understand how you're dealing with those kind of matters. And then the last thing, like I said, I'm speaking from a lay person. The issue of road accident fund again. Why a case like loss of support? You are being told, let's say the lawyer is being told, we cannot look into it, it has to go to court, even if it's a straightforward case that has got actuary, blah, blah, all those terms. Why should it still have to go to court? And they'll tell you it will not be attended. And then the last part again, the issue of, I think maybe it's when you talk about the case management, why would you go to court and then the date that have been given at the High Court for road accident fight is 2 years or 1 year? What happens in the process of the person that is being injured? Because there are no mechanism to say, while we are waiting for this 2-year court case, how are you helping a paraplegic? And then while the lawyer at the same time, they don't even have money to take these people for experts because the case will not be attended to as long as they do not have the expert matters. What happens to this paraplegic? These are my questions. God bless you.
Okay. Thank you, ma'am. I will take the last question from Ms. Lucas. We have almost run out of time for this session, unfortunately. Ms. Lucas? It's a comment. Oh, all right. She's given her slot. Up to you, ma'am.
Ngiyabonga, sanibonani. I would like to applaud the judiciary for the work that they have done in the High Courts, especially in South Gauteng and the North Gauteng, about our dates for the trial dates. They have been very long. We had to wait as legal practitioners, but now it's better. Thank you very much. We really applaud you for that. But there is still much that has to be done. I am very happy that there is this directive that says before the case can go for trial, there is this certification process and the case management, and that really is helping because some cases can be settled before we get there, before we get to trial, or they don't even have to get to trial, which is very good. But I just want to know, my concern is, why should a plaintiff wait for maybe that 1 year or 2 years while waiting for the trial date when all medical reports have been submitted? The Road Accident Fund will have the medical legal report, but they will still, when you call them as a lawyer, they will ask you, when is this matter on trial? Some of us do not even have funds to pay for the medical experts because it's expensive. And I think that is, there is injustice there somehow. We do not have money to pay for them. And number two is, why should we wait for so long? Why should the RAF say, no, we are not settling until we get to court when the money is available, or maybe they can settle? Why should they do that? Why must they allow the defendant attorneys to say, no, we are waiting for the trial date, when the matter is straightforward, it can be settled and all reports have been submitted? That is injustice. Because we are having somebody there who will be calling you every day, when will this matter ever end? And if they are very impatient, they will say, well, I'm shifting my matter to another lawyer because you're not doing anything. And we are losing business. We have to be realistic. Well, most lawyers have even left practice because we are no longer even benefiting. I think it's number 3.
Last one.
Yes. Why should the matters, for example, a loss of support matter, a straightforward matter, be defended? And, okay, it can be defended, but until trial, when it can be settled even before. Why can't the RAF give an offer? I think that, again, is the way of wasting taxpayers' money. Because these defendant attorneys will even be charging cost for something that is unnecessary. And that money should be put to good use. It is a concern, and I think this platform maybe is well equipped maybe to advise and to deal with these kind of issues. And again, I don't know what should I do with my child that is getting naughty in the house if I cannot spank the child. The kids are very naughty. If I cannot spank my child, what should I do? Because I'm not well equipped to deal with I'm not a psychologist. I don't know how to, take them to a naughty corner. I was not raised like that.
I'm afraid I'm going to have
Thank you very much.
ask you to stop. The last question was asked and answered by the Chief Justice. Chief Justice, please. Yeah. She's
I think I must start from the beginning, from the end go up. Look, we're employed just to interpret the law. We don't do as we please because we are not the law unto ourselves. And that applies to the spanking issue. You would recall there, we don't even mention any, corner? We don't mention any corner. We don't know those corners. So all I can say is the laws exist for our benefit, and if any law, any judgment does not seem to advance our collective interests, Parliament is available to make sure that it replaces that law with the one that we all agree would best advance our interests. So I think that's all I need to say. And as regard payment, the road accident matters, I've touched on it. It's all about, it takes us back actually to the intervention that we have taken or made at the National Efficiency Enhancement Committee level. Because part of what we say there is, some matters can just be speedily settled before you even go to court. Exactly the point that both of you were making. You can make an offer because all the documentation is there. You are satisfied that you have got no basis for opposing the claim. It may well be that you can agree on a reduced amount. So we've intervened. Let me just tell you the extent of our intervention. At the National Efficiency Enhancement Committee level, we went so far as to say some of the judges' presidents were attorneys and they did road accident matters. People like Judge President Lohodi, I don't know who else we roped in. So we identified them to work with the leadership of the Road Accident Fund so that they can clean up the system of all the wrongs that are there and make sure that it functions to the benefit of the people. That's how far we have gone. We've said, settle matters that can be settled, speed up the ripening of cases for hearing. And a colleague of mine just reminded me shortly that, some of these matters, you can actually take them to motion court if they are not opposed. And that lessens some of the complications that are there. So let us all agree as judicial officers, as members of the public, as the legal fraternity, as parliamentarians, that we work together to root out all these problematic things relating not just to the road accident fund and medical malpractice matters, but all other cases. Now, we understand the issue about people not having the resources to prosecute their road accident cases and other cases. Well, what we have done to make access to justice possible is, among other things, additional to the pro bono system. As a matter of practice here, and I believe my colleagues in the other courts also do it, what we do is, when somebody has a case, and we are not even able to tell what the person is saying, or it looks like there is a case, but the person is unrepresented and therefore doesn't know how to prosecute it properly, we take it upon ourselves in circumstances where Legal Aid South Africa, by reason of the limited budget, is not able to assist. We take it upon ourselves to ask the organized profession, and they have never said no, to intervene for free for the sake of those people that deserve assistance but don't know how to access it. Even the public interest litigation centers, there are a number of NGOs that are forever willing to take up most of these cases for nothing on behalf of the public. So in case of doubt, I think you can just get in touch with the registrar of a court, and or maybe even with Legal Aid South Africa. They will be just too willing, where they are not able to assist you, to refer you to an institution that would be able to assist. Training. We train traditional leaders under the auspices of SAJ because not only are they represented there, but they are involved in an adjudicative process, just like the judges and the magistrates. What you need is a public awareness system, and happily, lawyers from year to year, in collaboration with the Ministry of Justice and Constitutional Development, have been going out to the public to say, people, we are available to help. So there's a lot of goodwill there. When it looks like nothing is happening, just call somebody who operates within this space. You are bound to find somebody who's willing to help. I mean, you were watching television just recently. We learned that somebody was applying for bail. The feast must fall activist. There was dissatisfaction. A lawyer just came out and said, but I'll represent you for nothing. Our people are willing to contribute in the alleviation of the plight of those who find themselves in challenging situations. We've got community advice centers, for instance. I don't know if there is one in Soweto, but there are so many of them around, even in Winterfeld, I think, or is it Soshanguve, who can give you advice or connect you with whoever you need to be connected to, so that you can get the assistance you need. I think I must just thank you. I wish we had more time, so that it doesn't look like we are digging and diving when you want to put questions to us. I just want to thank you for your patience, although the vote of thanks will be given by, is it the President or the Deputy Chief Justice? I don't know.
Thank you very much, Chief Justice. I'm afraid we have reached the end of the session, and I now hand the proceedings back to my big brother, the Deputy Chief Justice.
Thank you very much, my sister, Justice Meyer, the President of the Supreme Court of Appeal, for facilitating the question and answer part of the session. Thank you to the Chief Justice for answering all the questions that were asked. And I think that this part about question and answer is quite important, because it is the one part which we can point to and say, here is when, at a very practical level, the judiciary is accounting to the people. Those who are here represent the people. We have run out of time, so we are going to try and close as soon as possible. But before that, I take this opportunity then to thank once again the Chief Justice and the entire leadership of the judiciary, the entire judiciary, and I include, when I say the entire judiciary, the magistrates, regional courts, all our colleagues at that level. I thank the Office of the Chief Justice for all they did to make sure that this function was successful. I thank all of you for coming to this function. I thank members of the executive. I thank members of parliament. I thank leaders of various institutions, state institutions, who came here to be with us on this occasion. We thank you very much for taking your time to be with us. We really appreciate it very much. At this stage, then, I am going to ask the choir to give us their final song, and thereafter I will come back then to close. Choir, are you ready? Please give us your final song. Please give them a big hand. Thank you very much to the choir, not just for this song, but for their singing throughout whenever we ask them this, throughout this function. I did thank Judge President Liu earlier on for her contribution. I just want to thank her again. I have thanked Justice Meyer, the President of the SCA, and the Chief Justice. So thank you to all of them. We have now reached the end of the proceedings. I've been asked to announce that there will be refreshments for guests at the foyer. So from here, guests are invited to go to the foyer. And as the judicial procession rises and leaves, we ask that all of us stand. So I will now return to my seat, and then the judicial procession will leave. Thank you very much to everybody.